Now, I want to go over this because I've seen this floating around, and people are saying that they turned you into a decedent, and that's the farthest thing from the truth. They didn't turn you into a decedent. The decedent existed already. Now, what they're pointing out, is down here at the bottom in paragraph. What they're pointing out is down here at the bottom in paragraph 2, but they're paying attention to this right here. And see, it's simple grammar. An infant is a decedent of an estate or grantor, owner, custodian, or trustor of a trust, guardianship, receivership, or custodianship that has yet to receive an SSN. So, now you can take everything out of the middle of it. An infant is a decedent of an estate that has yet to receive an SSN. So, what is a decedent? And why is it a decedent? And what is the infant? And what is not? So, let's go to the definitions of decedent. A decedent, a dead person, especially one who has died recently. The term is little used outside law. It typically appears in legal proceedings or administrative inquiries. So, something that died recently, you're not dead. You're a living, breathing being. Look at this decedent estate. And it says see estate number 3. Estate number 1 doesn't apply. And you got to go all the way down here. You got to go to all the way down here to find what a decedent estate is. The property that one leaves after death, the collective assets and liabilities of a dead person. So a decedent is something that died. And I've talked about this numerous times. The name on the birth certificate isn't you and isn't yours. It's a decedent estate. And that first document is the Internal Revenue Manual. So it hasn't received a social security number yet. So what is it converted to when it is receiving a social security number? See, everybody thinks it's about them, and it's not about them. It's converted into a trust through probate. Now, let's go over some facts in their own words, not speculation, in their own words. This right here is all 50 states. And this is actually according to the federal standards. So, let's go down to page 6. And I like New York because it's got a great part. Right here. Live birth. Live birth is a legal term. You're going to see it live birth, live born, or born alive. That is for a decedent, something that was alive when it come out and it died. And we will go over the definition of that shortly. Live birth is defined as the complete expulsion or extraction from its mother of a product of conception, irrespective of the duration of pregnancy, which after such separation breathes or shows any other evidence of life, such as beating of the heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, whether or not the umbilical cord has been cut or the placenta is attached. That's the definition of live born. And then it says what? Each product of such a birth is considered live born. How many products? There's 3. You got the baby, the umbilical cord, and the placenta. So look at here, number 2, a showing that an infant at the time of birth was capable of living a separate and independent existence, regardless of how long the infant actually lived. See, the infant died shortly thereafter birth, and it was placed into probate. Vital Records has said that. I've got videos on my YouTube channel where they admit, yes, a probate file was created, but we can't discuss our internal policy. People are running around saying it's them and it's theirs and blah, 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 blah. No, it's not. It was placed into probate because every hospital has one room set aside just for probate proceedings. I have confirmed this in one state in Minnesota. Now, let's look at the Kentucky Code. Y'all have heard me say that the mother, during the prenatal visit, signs a contract giving assignment over the infant, not the baby. So she gives assignment and places the infant and herself under the care of the hospital. Y'all are familiar that a lot of the birth certificates are what? She is labeled as an informant. There's a reason why she's labeled as an informant, because she is not in her capacity of mother. She is under the capacity of custodian, and it has nothing to do with the baby. The person who assumes the custody of a live-born infant of unknown parentage shall report on a form and in a manner prescribed by the state registrar within 5 working days to the Cabinet of Health and Family Services the following information: the date and place of finding, sex, and approximate birth date of child. Why is it approximate? The state has no first-hand knowledge, and neither does the state agencies, and neither do you. Name and address of the person or institution with which the child has been placed for care. Infant and child are synonymous. Infant and baby is not. So the child or infant was placed into the care of the hospital. And paragraph D says what? Name given to the child by the custodian of the child. Does it say mother? No. And if you think that this is just Kentucky, no. It is worded this way in all the federal territories, and it is worded this way in almost every single state. In North Carolina, it is not worded this way. It's one of the few states where it's not. It has a little phrase that I'm not going to get the phrase right, but it's according to the federal standards or according to the federal agencies. This is the federal standard for the infant, not the baby. This is my footprint document. That little paragraph is a contract at the bottom. I certified that during the discharge procedure, I received my baby, examined it, and determined that it was mine. I checked the identiband parts and sealed on the baby and on me and found that they were identically numbered. But you know what? Almost nobody, when you look at the name on it, it doesn't have the name you thought you were given. Because why? They don't know the name of the baby. This was the firstborn infant to this type O Rh positive mother whose expected date of confinement was 9/24/73. Confinement because an inmate is someone that's in a prison or a hospital. But what does it start saying on the 4th line? He was found to have a birth weight. There's that foundling or lost infant. It doesn't say the names. You're making presumptions because you think it's about you. Where the infant died, it was placed into probate. It's been in probate ever since this, and it's in trust. The state is the grantor of that trust because it was placed into probate under care. And there's the trustees listed, and the state's the beneficiary. Who do they go to get their Title IV funds and Title II and Title V and other funds? They go to the third trustee. I just had a nice conversation with the DM at Social Security almost 3 weeks ago about this exact thing, about me being the lawful representative. They sent me a letter. It wasn't worded right, but they did say lawful representative, and they did say there is no guarantor listed on the account. Y'all are out there putting information saying they made you a decedent. No, the problem is you are making presumptions about the entity that you can't prove in court. Oh, my mother gave me an affidavit. Well, during the process, she was legally incompetent under the law because she was under the care of another. Plus, she was unmedicated and everything else from the time she signed that contract till about a month after birth. The only person that's competent to declare his offspring is the father, and none of us fathers have ever done it.